protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future.
You're live.
Here's Gary.
Hey, everybody. Happy Monday. This is Gary Quackenbush on the Word on Wealth. Really good to have you along. We're going to travel through the week as follows. Today, we're going to have Rich Mathurin from GQ Law come on and talk to us. It's at the bottom of the hour. He's going to talk to us about getting a fresh start, dealing with taxes, maybe ways to wipe them out if you have back tax issues. That's coming up today. Then tomorrow, we're talking about trust administration, how to distribute money from a trust, how to act as a successor trustee, who you might want to choose as a successor trustee, and like wills and trusts. That's going to be tomorrow. Then on Wednesday, we have Ken Pecos, real estate guru, expert guy that we just love to have on talking. And there's a lot of talk about that addition to the show because it's a big deal in San Diego, real estate. The next thing, it's Thursday, we've got Anthony Wright, all things money, and helping us deal with the money markets and how to make money, regardless of whether the S&P is going up or down, which is always fantastic. And then on Friday, we have our Finding Joy Friday. And this Friday, we're going to have a special guest on, and that is going to be Kip Harris. Awesome dude. All right. So for today, here's what we're going to talk about. Powers of attorney, because there's this relentless misunderstanding of what a power of attorney is good for. So I want to talk about that, compare that to being a successor trustee and when you do one or the other. And then I want to talk a little bit about charitable trust. If we get some time, we'll be going over what I call it's too late now. What happens if you wait too late to get a trust or to amend it like you wanted to? Power of attorney, first thing. It's a document. A power of attorney is a document that gives power to someone, just like the document says. It gives somebody becomes, by virtue of the fact that you create this document, it has to have very specific language. You assign someone to be what we refer to as your attorney in fact. It's not an attorney by going to law school and getting a license and their Juris Doctorate and being sworn in the California bar like me. It is an attorney in fact, meaning you have assigned this person the duties and responsibilities to take over and to function, perform some functions that normally only you can do.
Speaking of facts, Gary, it's a fact. We have a call. We have Rob from Mission Valley.
Rob from Mission Valley. Welcome to the Word on Wealth. How you doing today, Rob?
I'm doing fine, Gary. Hope you're doing just as good.
Excellent. Doing well. What can I do for you today? What's your question?
Gary, this is a question based on an article I read recently. The article said that a property such as a home, if it's held in an irrevocable trust that's not included in the taxable estate at death, would no longer be available for a step up in basis. Did I read that article right, or am I missing something?
Okay. It sounds, first of all, I'll guess whether you read it right or not. I'm assuming you did, but I think what it's talking about, and I'd have to know a lot more context. That's going to be a little hard to answer on this show. But with an irrevocable trust, what's happened is there's been a transfer from the individual to this trust, and it's an irrevocable transfer. That irrevocable transfer is what's going to trigger the disposition of the property. And disposition is when you have that's when you have the tax consequences. That's when you'll have the potentially the property tax increase, or it's going to be considered a disposition. And that disposition is, if anything, that's the time that you would have a step up in basis. However, what you're not doing is the person isn't dying. So there's no reason to step up the basis. It's a living person to an irrevocable trust. That's a disposition of the property, but is not an inheritance. So it's not considered, it's not going to cause a step up in the purchase basis of the property. So because it was not irrevocably transferred in, I believe what you're reading is it's saying that at death, when the irrevocable trust transfers to an individual, that it doesn't qualify for the wealth transfer exclusion, or I'm sorry, it doesn't try, it's not considered, it doesn't get a step up in basis. I think that's what you were reading. Does that sound about right?
Uh, I guess so. Eventually, it may come down to my sending you the article. It's just a short paragraph. It was in the Kiplinger magazine, and it made it sound like it's a recent adjustment in the handling of estates under trust. But I can pass it on some.
Yeah, you can pass it on because
Otherwise,
I don't think it's a new change. Not that I know of, but a lot of people get into this irrevocable trust. Like, I want this irrevocable trust because it's going to protect my assets from creditors and all that. And all of that may very well be true. But when you do an irrevocable transfer, that's the thing, is it's irrevocable. And so to get the property back, to be able to sell it, to get it back into your name, you have to reverse an irrevocable transfer. So you can kind of see there's some interesting legal play on words on that one. It's an irreversible transfer that you're trying to reverse. And, you know,
2 minutes.
so people use it as an asset protection device, because they say, well, it's not my property anymore. It now belongs to the trustee of that trust over there. But then that's the problem.
The key seems to be the term irrevocable, whereas most trusts are considered revocable. In other words, as long as the person who made the trust is alive, he can make changes. Is that correct?
That's the definition of a revocable trust. Yes, is that the person that created the trust can make the changes. And I don't know in the article, you have to send it to me, whether is that the distinction they're making, because there's a lot of, yeah. Well, that very well could be. Thank you, Rob, for always asking interesting questions when you call in. Sounds good.
Okay, buddy.
All right. You're listening to Word on Wealth. That was Rob from Mission Valley. Thanks for calling in and helping us asking that
About a minute.
tough question. We are going to, let's see, what we're going to do is I'm going to talk about not irrevocable trusts. We're going to talk about power of attorney and what that does. Power of attorney document is actually something where you're going to give authority to somebody to do something for you. And how that power of attorney works is really important, and what you're allowing somebody to do. So the basics of the estate plan, of the power of attorney, the basics are that if you want somebody to do something for you, you give them a power of attorney. You can give them a limited power of attorney, a general power of attorney. That power of attorney can also be what we call springing power of attorney, or it can be a durable power of attorney. So those are all different conditions of this document. There's not one, do it all power of attorney. There's reasons to have one or the other. You're listening to The Word on Wealth. And if you want to get a hold of me to have an initial free consultation with me, call me at 855-500-TRUST. Let's talk about your estate plan. Let's put together an estate plan for you. Make sure everything's taken care of. 855-500-TRUST coming up next. Power of attorney and what different types should we be concerned about?
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQLaw.com.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is Faith-Based Investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, your team at GQ Law are experts at solving IRS and state tax problems. Talk about that.
When people have a tax problem, it tends to really stress them out. And one of the things we've been able to do is figure out how to resolve tax problems. One thing we might be doing is setting up a payment plan or getting a collection delay, maybe getting a determination that the person shouldn't have to pay the taxes at all. We do offers and compromise. We do audit reconsiderations. And one of the things that's a really powerful tool that some people don't recognize is sometimes bankruptcy can be used to actually eliminate taxes when there's certain conditions of the code that are met. So we can do all kinds of things. After we analyze your situation, we can figure out what's available, discuss your options, and figure out which ones to implement, what it's going to cost, how long it's going to take. And we can get people out from under all kinds of tax problems so they can sleep again. That's our goal.
Request your free initial consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
Who will you trust with the biggest financial decision of your lifetime? If you're planning to buy or sell a home in San Diego County, do what I do and work with the true San Diego real estate experts. Ken Pecos and the Pecos Group helped me and my family. They can help you. This is Gary Quackenbush of The Word on Wealth. You hear Ken every week here on The Word on Wealth. He's our expert. He's got integrity, exceptional service, deep knowledge of the San Diego, Coronado, and South Bay regions. These are just some of the reasons that Ken Pecos has completed hundreds of transactions. He manages a powerful team of professionals at the Pecos Group, from single-family attached homes to luxury high-value waterfront properties to apartment buildings. Ken Pecos is ready to help you avoid problems and costly mistakes. Learn more online at kenpecos.com. That's Ken Pecos, Pecus.com. Or call 619-977-8419.
DRE number 010566969, brokered by eXp Realty.
Lots of channels, nothing to watch, especially if you're looking outside of big corporate control. It's time to interrupt your regularly scheduled
About this broadcast outreach, The Word on Wealth with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, GQLaw.com.
You're live.
On The Word on Wealth, we are live and local here in San Diego. Good to have you along. We are talking about power of attorney forms. Talk about them a lot because I see them too much, and I see the problems that they bring up. I will tell you that the biggest problems that I've seen in my career are the ones over power of attorneys being abused or having guardian things. And I've told you that before. The guardian designation, kids not getting the proper guardian designation or having problems with that. Those are the ones that bring up the really scary, awful stories that I don't really like to have to deal with, but we deal with it quite a bit. So the thing with power of attorneys, here's the way it goes. There's a general durable power of attorney. If you give somebody a general durable power of attorney, it means two things. General means it can do anything that you could do legally as an individual. And durable means that it even works if you're incapacitated. So if a power of attorney doesn't say durable on it, that would mean that the person using the power of attorney to do something for you would have to be able to establish that you have the capacity and that you have the capacity at that time, which is really difficult. So most all power of attorneys are durable, which means even if the person that signed that after they signed it became incapacitated, that power of attorney is still in effect. Okay. So what's the problem with that? Well, one, if you're incapacitated and now you want to revoke that power of attorney, it's impossible because you don't have the capacity to revoke it. That's why you need to make sure that whoever has your power of attorney is really a person that you can trust 100%. The thing about general is it literally is general. You see general durable power of attorneys that are sometimes, 5 to 15 pages long, explaining all the things that a person can do. So I had a case situation. This was years ago. It was really kind of it taught me a lot about power of attorney. And I had a guy come in and he said, "Hey, I want a power of attorney, and I want it to be very limited. I want it to say that my wife has the ability to sign the paperwork necessary to refinance our home, and that the power of attorney is only effective for 6 months." I said, "Okay, I'd love to know the backstory." And the backstory was that they're in the middle of a refinance. And while they were doing it and having all the paperwork and all that stuff going on, they still weren't done. But he had a motorcycle trip planned with a bunch of his buddies, and they were going to go coast to coast, California to East Coast, back to the West Coast. And they were going to take several months to do it. And he wanted this power of attorney so that his wife could continue on finishing up the refinancing, which anybody that's done it, which is probably most all of you, it's really a lot of work. Okay. A lot of work, a lot of documents, a lot of stuff. And the reason he wanted it limited is because he didn't want his wife. And I just got thinking, like, well, she's in the middle of they're in the middle of a refinance. He's leaving it in her lap, and he's leaving for several months to drive with his buddies back and forth across the United States. What a good time. Well, if he gave her a general durable power of attorney, then while he's gone, he may return and find out that somebody else owns that home by the time he got back, because she'd be able to sign his name to whatever documents she wanted to. So Jeff, if she got a general durable power of attorney, even if the bank account were in his name only, she could get it. If the house were in both names, that's fine. She can sign for herself. And with his power of attorney, she could sign for him. If she wanted to get financing, as obviously we talked about, then she could sign the finance documents in her name as her and in his name as his power of attorney. So the general durable power of attorney would have let her do anything. Yet I see people that come in and they say, "I want you to review my estate plan." And they have a general durable power of attorney that's 15 or 20 pages long that authorizes this person, this assigned individual, the ability to make all kinds of decisions. I mean, every single kind of decision you can imagine: buy and sell property, buy and sell stocks and bonds, invest in things, get a rental, all kinds of things. General durable power of attorney. And another big challenge with them is you can't get rid of them, because the power of attorney, for a bank to accept it, or any institution that really knows what they're doing, they want the document to say that this document, a copy of this document, is as valid as the original. And why would it say that? Because if it didn't say that, then the bank would have to be determining whether the document you brought in was the original. And they don't want to make those determinations. So they want it to say that the copy is as good as the original. Well, that's a problem, right? So that means if there's 20 copies out there, and the person that you no longer want to be your general durable power of attorney, how do you get all those documents back? You've got to, how do you know how many copies were made? Because a copy is just like the original. Power of attorneys are dangerous. Power of attorneys need to be controlled, and you need to be able to make it so that they're not very easy to use. And sometimes that's a pain when they get used, but you can still do it where someone can serve as your power of attorney in the event of your incapacity, or you can make limited durable power of attorneys. I most always just do limited durable power of attorneys. And I give the power of attorney, or the client gives the power of attorney the authority to move bank accounts, deposit accounts, money accounts, investment accounts into the trust in the event that that person is incapacitated. So if it were me, I'd give a limited durable power of attorney to my wife or to my son, who would be my successor trustee. If I became incapacitated and my wife goes to the bank and she goes, "Oh, wow, we got with this joint bank account is not in the name of the trust. I want to put it there." The bank's going to say, "Well, where's Gary?" So she's going to need a power of attorney for me. Or if there's an investment account, "Where's Gary? This is his joint account. We need something from him that says that you can do this." And you don't want those things to happen. It doesn't always come up, but when it does, it's very annoying because you can't move the money and do what you need to. So power of attorneys, review them. If you have one, great. If you have a general durable power of attorney, I really think you should question yourself, like, why do I have that? If you have questions on this, you want to talk about it, free initial consultation, 855-500-TRUST. And if you have, a good friend of yours that's an attorney and knows what they're doing, and they're very familiar with power of attorneys and estate planning and all that, that's great. That's great. Awesome. Use that person and, get the counsel you need. If you don't have that kind of person, let me be that. 855-500-TRUST. Let us help you out, figure out if you got the right documents and whether it's too much. Along with that power of attorney, I believe that almost everyone should have a living trust. And if you have a living trust and your property, bank accounts, car, house, investments, if they are properly in that trust, they're properly funded into that trust, they're properly controlled by the trust, and therefore properly controlled by your trustee, which would be you, or successor trustee would be the person that you name in the event of your incapacity. If those assets are in that trust and controlled by that trust, you know what? You don't even need a power of attorney because the trustee has the control over those assets. So why would you need a general durable power of attorney that allows someone that you name to do the refinance of your home, to sell your home, to sell your car, whatever? You just don't. You really don't need a general durable power of attorney. It's not necessary in almost all cases. If it gets to be where, there's other things that are outside the trust that need to be handled, I think it's a situation by situation determination analysis that you need to make. It's not for everyone. I don't do general durable power of attorneys for that many people because I've never really found a big need. The real times that you get the big need is it might be a business related thing, or if things weren't put into the trust. If you have a bunch of bank accounts that are outside, there's no beneficiary designation. If you're single and there's nobody joint on your accounts, maybe you're going to need a power of attorney, but I'd rather have you put them in the trust and have the trust handle that, because the trust has specific language on what the trustee can do. It says exactly what they can do and who they need to serve. The answer is they need to serve you as the beneficiary as long as you're alive. A power of attorney doesn't have that. A power of attorney just says, Joe has authority to transact all real property transactions, all personal property transactions, to buy and sell property, to buy and sell stocks and bonds, to buy things on margin, to buy puts and calls. I mean, there's the general durable power of attorney has all these different things that, we probably don't even realize that we actually have the authority to do. Well, you're handing it all over to somebody else. I don't think it's necessary. I want to know why you want a power of attorney, and I want to tailor it to your needs. 855-500-TRUST if you want help with that. Doing that, it's not the only thing we're going to do. We're going to look at your estate plan. If you don't have one, you need to put one together. Let me help you do that. 855-500-TRUST. As part of the comprehensive plan that we will put together, we're going to be discussing whether or not you need a power of attorney and which kind. General durable, limited durable, springing power of attorneys, those are going to be the considerations, and it depends on what your needs are, where your assets are, what's happening, what's going on timing wise. Give me a call, 855-500-TRUST, and we can work through that. A couple of things that I would also, recommend is hanging on for the show we're going to go right to the top of the hour. Next, coming up, we're going to have Rich Mathurin, an attorney from GQ Law, talking about money and about fresh starts. We're going to be doing that in just a couple of minutes. If you want to find out more about living trusts, I have a free book on my website. The website is gqlaw.com. GQ like my initials, Gary Quackenbush, gqlaw.com. And you go in on, basically it's on any page on the right-hand side, there's a book cover that says Living Trust Basics. You click on it and it asks you to put in your name and your email, and it will send you a PDF of a book. It's about 20 pages long. It's really a super short book because it's done in an outline format, and it will help you and have the information on the Living Trust Basics. And if you do want a consultation with me, you can do that on my website as well while you're there. And you can go to my tab that says free stuff. and get some free stuff like guardian designation. There's free articles, there's stuff to pass along. There's some information that would be helpful. That's gqlaw.com. All right. Coming up, we got Rich Mathurin of GQ Law talking about fresh starts. So if you have a situation or a family member and they're having some, financial struggles, trying to figure out what to do with their financial life and trying to make ends meet, maybe the credit cards are just pumping higher than they can handle. It might be time to call them and say, gotta tune into the show, because we're going to be talking about managing debt, getting fresh starts. We're talking a little bit about what about individual reorganization, what about a discharge, like in a bankruptcy situation, what that's all about, how it affects you, how it affects your credit or not, who gets to use it, who qualifies. We're going to be talking about those things coming up next here on the Word on Wealth. Free consultation, 855-500-TRUST. Make sure you get your call into me, get on my schedule. It's kind of tight this summer because people are traveling and people are figuring it out. 855-500-TRUST. We'll be back with Rich Mathurin on GQ Law.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at GQ Law. Five, 500 truck.
July.
All right, you're listening to Word on Wealth. We're on our Monday show, and we're now at the second half of our show. So we got Rich Mathurin from GQ Law. Rich, welcome to the show.
Great to be here again.
Gosh, it's every week, man.
Yeah.
You're like a professional.
Yeah. I'm also appearing at the Comedy Store. I'm just kidding.
That's right. I'm here till Thursday. That's right. We've got veal. Yeah, try the veal. I'm here till Thursday. So Rich and I were talking about, what should we talk about, with our, our listeners. We talk about the Word on Wealth, and usually it's having wealth and that kind of thing. But we all have people in our lives that don't manage money well, or have situations in their life that are just, they've run onto hard luck. They've had to use their credit cards. It's the economy. It depends on the news cycle you listen to. It's doing great. It's doing horribly. So there are a lot of segments of our economy that are really suffering. And one of the things that Rich does here at GQ Law, at the law firm, is he helps people get out from under these like crazy tax burdens and also under crazy debt burdens. So we want to talk a little bit about bankruptcy and kind of where that came from. And my questions really are like, what is it? Like, who is it intended to help? And then who qualifies? So I think, Rich, why don't we start out? Talk about basically like, what is it about? Because most people, they go, oh, bankruptcy, that's a dirty word. And we don't say those words in public, but talk about what bankruptcy is.
Yeah, I think bankruptcy, the founding fathers really wanted to have in England, they were fleeing a lot of things, but one of the things they were fleeing was debtor's prison, where, if you owed a debt to another person or the government, you could be put in prison for that. And in Article 1 of the US Constitution, there's a specific provision provided by the founding fathers to allow for bankruptcy. Basically, bankruptcy is just a fresh start. It allows you to give you a fresh start so you can become a productive citizen going forward. If you have all this crushing debt and you aren't able to function, you aren't able to work, and most people, if they have creditors chasing them all the time, they just can't function. So bankruptcy is a way. It isn't, if you have the income or assets to pay for your debts, then the government's going to ask you to do so. But if you don't, then bankruptcy is a great option for a person.
Yeah, it's not like somebody that, they just, I just feel like I don't want to pay my credit cards. I'm going to go apply for bankruptcy and get rid of my credit cards and start over. I mean, you have to qualify.
Yeah.
And so there's two, there's like three different types of bankruptcy, but talk about the two main ones, the difference between like the discharge chapter 7 and then the chapter 13. What is kind of what are these two kind of potential options that people have?
Well, the chapter 7 is what we would call a liquidation bankruptcy. That's where the debtor does not have enough assets to fully pay on his debts, both secured and unsecured. A chapter 13 is where they do have income and assets to pay some portion of their debts, and they would get into a monthly payment plan based on those income and assets, usually from 3 to 5 years, usually 5 years, and they would pay their secured creditors in full and their priority creditors, which would be your taxes and alimony, child support, those things, on a full basis. And then you're unsecured on some type of either 0 cents on the dollar to 100 cents on the dollar, depending on your income. I guess I would characterize the chapter 13 as a reorganization.
Okay. So the possibility then, so if you're thinking, I have a mortgage on my house and I'm going to file bankruptcy and wipe it out, that's not going to happen.
No, that a mortgage is what's called a secured lender.
Okay.
They have a security interest in your property that they file with the San Diego County Recorder's Office. And before that property can be sold or refinanced, that secured lender, the secured mortgagor, has to be paid off. So they have a secured lien. They would be called what they call an in rem creditor, and they're a lien creditor, so they would be paid in full. They would generally, on a chapter 13, they would be paid outside the plan. I guess the one thing I would say is if you do get into an arrearage where you get behind on your mortgage significantly, like, $20,000, we can do the chapter 13, put that arrearage into your plan. It can be paid off over the 5 years. So that's a big advantage. People they don't want to lose their home. So the chapter 13 might be a good thing in that case. But with a chapter 7, we are able to protect about, I think it's $660,000 in San Diego County in equity now. They changed the laws to increase the homestead exemption up to that amount. So you can generally protect your home in a chapter 7, but you're not going to be able to discharge that mortgage debt.
Okay. So then the idea of I guess we'll talk about the reorganization with the home is that, so if I am behind on my mortgage and I've just fallen on bad times and I ran out of money and now I'm $5, $10, $15, $20,000 behind. If I am now able to start making the regular mortgage payment, I might be able to go into a reorganization, and that would bring my loan current by paying the arrearages in the Chapter 13.
Yeah, you would have, it would be put into the plan and paid.
Okay.
If, I think the debt limit for 3 years is like 33,000, and over that would be a 5-year plan. So you'd have, 60 months. A lot of people are coming up. Remember about those COVID forbearances, that
Oh,
a lot
that's
of
right.
those, the mortgage lenders gave you. That did not, free you from paying those payments during the COVID times. It just is going to, you're now, those amounts are now due and payable. So unless you can reorganize, you can get put it onto the back end of your loan with your mortgage company. I would suggest that maybe a Chapter 13 might be a good thing for you to put that COVID arrearage that you have into a Chapter 13 plan and pay it off over 5 years.
Interesting, because when the COVID forbearance loan balance, because the amount, the forbearance is the amount that the lender said, okay, during COVID, we can't collect money from you because you don't have money, and now it's due and payable. If that does not get paid, that's just like part of the regular home loan. If it doesn't get paid, they foreclose, correct?
Yeah, they can if you don't call them. I do think a lot of them have to have things where they can put it on to your end of your loan, but if you don't get any type of an agreement on that, they can foreclose on you. And one thing about California is they can foreclose up to the value of your loan. They can't go after you for the additional loan if you're it's only up to the value of the property.
Right.
So if they sold it in a foreclosure, they could only get up to that amount. They couldn't pursue you for the additional amounts that you owed on your loan. So that's one thing good to keep in mind for California, but don't want to lose our home regardless.
Yeah, exactly. So then when you talk about, so somebody, let's say they got behind in their credit cards. I mean, so here's a scenario. I had somebody that was talking to me about, he was saying that he's making the minimum monthly payments. He's really struggling. Financially, he's kind of just doing the best he can. He's a huge amount of credit card debt, about $50,000 in credit card debt. And then, so huge amount of credit card debt, but he was staying current. He wasn't like 90 days behind on anything. He was making payments, just barely struggling to get them done. And then he went to a debt consolidation company that said, well, to negotiate for you, you need to be in default. So they made him like not make payments on at least one of his credit cards for 90 days. And that put him in default. But then it crashed his credit and all of his credit cards went into default, and they all jumped to that 29.9% default rate. So now his minimum monthly payment was about double what he could afford to pay. And because of this attempted quote reorganization, he was now headed for bankruptcy because he literally, all the cards were basically wanting all their money, not all their money, but they now had their minimum monthly payments based on the new 29% default rate. But it kind of triggered, it triggered this problem that I don't think he anticipated, thinking that he was going to be able to negotiate his credit cards. And then suddenly he was like almost forced to be in bankruptcy, and his credit was like shot by that time.
Yeah, my understanding with those debt consolidation programs is they really don't get you any less amount that you owe on your credit cards. They do get you better, more time to pay or whatever, but you end up paying it all of it back plus interest. So my suggestion, if you're going to go that road, just go take the extra step and do the bankruptcy. We can discharge all of the credit card debt, all the pre-petition credit card debt, and give you a fresh start. Again, it's not, you're not trying to get rid of your, if you don't have the ability to pay, it's giving you a fresh start where you're saying, in the past, I haven't had this ability to pay, but in the future, I want to be a productive citizen and use my income going forward. But if you have this crushing debt where you're just making minimums and you're never going to get ahead.
1 minute.
And so I would suggest the bankruptcy versus those debt reorganization programs that really don't do that much for you.
Interesting. Well, Rich, we really appreciate you talking about that stuff. You're listening to The Word on Wealth here with Rich Mathurin from GQ Law, and we're talking about bankruptcy and how that helps potential fresh start. What we're going to do is, coming up next, what I'm going to ask Rich or have him talk to us about is, what about taxes? Because so many times people say, oh, taxes, they don't go away in bankruptcy. They're just going to be with me for the rest of my life. So we're going to have Rich talk about that specifically, like, can a bankruptcy eliminate taxes? Can it reduce taxes? Can you reorganize them? How does that apply to a tax debt? And that's more technical, but we're going to do a great job explaining that. That's coming up next here on The Word on Wealth. if you got questions for us, or if you want to meet with Rich and talk about your taxes, your debt issues that you want to have resolved, the number is 855-500-TRUST. 855-500-TRUST. You can call and just say, hey, I want to talk about a situation with my credit cards, with my debt, with my taxes. I need to get it resolved. That's 855-500-TRUST. All right, we'll be back in a second.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
How do you and your team help our listeners avoid probate?
Well, first of all, probate is a process that involves attorneys, judges, and sometimes contesting parties. And so we try to avoid probate at pretty much all costs. The way we do that is setting up living trusts, setting up properly documented wills, putting the property like houses, cars, bank accounts in that trust so that it avoids probate. Probate is only necessary if the estate plan isn't set up quite right. So we help them get it set up right. And mainly that's done through a properly created living trust.
Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free initial consultation. That's gqlaw.com, 855-500-TRUST.
Time.
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQlaw.com.
You're live.
All right. Welcome to Word on Wealth. You've got Gary Quackenbush. You've got Rich Mathurin. We are here talking about getting a fresh start. If you are, if you're in that situation where it's like, man, I cannot dig out of this hole. I had a good job. Now I'm down to part-time, or I lost my job. There are provisions in the U.S. Constitution, in the law, that allows you a fresh start under the conditions that we're talking about. I think of it, I've always thought of bankruptcy, Rich, about, it's like, you see the commercials and it's for the life alert where somebody's fallen down and they go, help me, I've fallen and I can't get up. And it's like, press your life alert button. And I always thought of bankruptcy as that, like, I can't get ahead. I'm trying to make my minimum monthly payments. My credit score is going downhill. And now I can't make my car payment and things are just kind of spiraling out of control. And it's like, I can't function. I'm starting to be angry with everyone. I'm not even doing well at work. Help me out. So we talked about bankruptcy a little bit on how that helps with the fresh start. Now let's go one step further. You were saying that there's such a thing as eliminating or even controlling taxes in a bankruptcy. Talk to us about that.
Yes, taxes have to meet certain criteria to be discharged in a Chapter 7. That's the liquidation bankruptcy. There's a three-pronged rule. It's 3 years from the date the taxes were due, 2 years from when it was actually filed by the taxpayer, and 240 days from when it was assessed by the IRS or the California Franchise Tax Board.
And you're talking about, so that we take each tax year and look at them separately. So if we're looking at, like, say, a what would be like a 2015 tax. Somebody owes money for 2015. And then it was due April 15th, basically of 2016.
Yeah.
So 3 years means it has to be, you can't file bankruptcy before 3 years due. So if it's due on April 16th, it's 17th, 18th, so 2019. If there's an extension, it's not April 15th, it's going to be the
October
16th.
Yeah, it has to be after that.
Okay. So that's the due for 3 years.
Yeah.
And then that same, the same thing, the date of filing plus 2 years, the date of assessment plus the 240 days. Okay.
Generally, the date of filing and the date of assessment are generally the same, but can be different in certain cases. For example, if you were to file a current year 2023, I could not discharge 22, 21, and 20, but anything back beyond that, those returns, those balances could be dischargeable. One caveat that I will mention: if you did not file your own tax return and the IRS or the franchise tax board prepared a dummy return for you in that year, even if you fixed it later on, those years would not be dischargeable. So if you failed to file in any year and the IRS or the California Franchise Tax Board prepared their own return for you in place, that year would not be dischargeable, even if it met the three-pronged rule. So that's one thing to keep in mind. But in a Chapter 13, those unfortunately taxes become a priority debt, and they would be treated more as a secured debt. I believe the interest and penalties probably would not be paid through the plan.
So because the tax liability, and I'm glad you brought that up, because in the Chapter 13, what we're trying to do is, like you had mentioned, there's the secured debts, and then that get paid in full in the plan, and then the priority they get paid in full but no interest, and then you have the unsecured non-priority. So in that same test of if they're 3 years old, filed for 2 years, and assessed for 240 days, you can actually classify some of the tax years as unsecured non-priority.
Yes,
and that's the tricky part, because I'd love to believe they're all unsecured non-priority. We got to look at liens and lien filings and equity. But the possibility, and that's the cool thing you're mentioning in the Chapter 13, is you may be in a Chapter 13 getting, it's almost like this whole salad of stuff, but you may be able to like wipe out credit cards, wipe out your old taxes, get rid of a judgment against you, and as part of the plan, maybe even paying some of your taxes back that you have to pay, and maybe even catching up on your arrearages. So it's like there's a bunch of things that can be done in the 13.
Yeah. Remember, the unsecured debt is paid on a 0 to 100% basis,
Right.
depending on your income and assets. And we can run through those tests for you. We have our software can figure out roughly what your monthly payment plan would be, and what your unsecured creditors would get roughly.
So that's I guess where you look at this. It seems complicated, and it's not easy to explain on the air. Rich does a better job when he writes it all down. But so basically what we're doing is, if you have this kind of a debt mess and you've got creditors that are kind of coming in, and I always say, now they're kind of biting at your toes, and now they're trying to take your money. It's like the Chapter 13 is like this personal reorganization. It's kind of like when you get these big companies that file for bankruptcy. I mean, there's sometimes an airline will file, or there's a big company that will file for bankruptcy, and everybody goes, oh no, they filed for bankruptcy, they're done. It's like, no, they're not done. They're reorganizing. They're going to sell some stores off. They're going to restructure. The Chapter 13 does that for individuals, and even including the taxes. So Rich, then, is it like, let's say that somebody really was, they're getting really hammered by just a regular creditor. The creditor went further and then went to judgment, and now they're trying to go after wages. How do you stop that creditor from like taking the bank account or taking those wages?
Well, one thing nice about a bankruptcy, whether it's a Chapter 7 or a Chapter 13, upon filing, a automatic stay is put in place by the bankruptcy court. That means that all creditors, regardless whether they're secured, unsecured, have to go through the bankruptcy court. They cannot do any involuntary collection activity. They can't garnish wages, levy bank accounts, file liens, file lawsuits. They have to do everything through the bankruptcy court, and they're notified immediately. We can notify a foreclosure creditor on the day. We can notice the foreclosure company and the creditor with the notice of filing. So it's a very, very powerful weapon that stops all collection activity immediately upon the filing of the bankruptcy case, and everything has to be done through the bankruptcy court. Again, for the Chapter 7, that's a liquidation bankruptcy. Probably all the debts would be discharged. The Chapter 13, that's the reorganization where you have to work with your creditors on a plan that the secured creditors get paid in full and the unsecured get some portion of their debt based on your income and assets.
So if you're in the process of almost losing your home because if it's in foreclosure or whatever, because I think we've seen this, like somebody will be trying to work with the mortgage creditor and they're just tired of it. They go, we're done. You're so far behind in your mortgage. We're just foreclosing. And they're going through that foreclosure process. So the bankruptcy can actually stop that process before the sale.
Yes, you can. You immediately upon filing, you get a notice of filing, and you can fax that to the foreclosure company. You can fax it to the sheriff's office, and that would stop. I have stopped foreclosures on the day. I mean, please don't wait that long. But
Right,
I have stopped foreclosures that were happening at like noontime at 9 o'clock in the morning on a Monday morning. So it's not fun for us, but we can do it.
That's crazy. Then that's the stressful day. We got Rich. What's going on?
Mhm.
What about the IRS? I mean, because IRS, they don't even have to get a judgment. They can take your bank accounts and all that. How about stopping them?
Again, a bankruptcy stops all involuntary collection methods for the IRS included, the state of California included. They are subject to those bankruptcy laws. They have to work through the bankruptcy court and they would file their proof of claim showing what they're owed.
Mm-hmm.
And then the trustee who is appointed by the U.S. trustee administers the bankruptcy estate. If there are, with a Chapter 13, we get a plan that gets their debt paid off over 5 years. With the Chapter 7, the trustee has to determine if there are any assets that are available to pay off creditors. They would only represent the unsecured creditors in that case.
Okay.
One major thing that I neglected to mention, but that is key with taxes. If your tax debt or your business debt is more than 50% of your debt, you do not. For Chapter 7, you don't have to take the income test. There are two income tests. There's what's called the means test. That's a 6-month looking back your average income. And if you're over a certain threshold, they don't want you to file Chapter 7. They push you into Chapter 13. But if you're again, your debt is more than 50% taxes or business debt, maybe you had an SBA loan and you had a personal guarantee on that. Those type of things, you would not have to take the income test. The second income test is sort of a budget test. If your net income, your income less your allowed expenses is at a certain level, if it is a surplus, that sometimes the trustee will try to push you if that surplus is too high, the trustee will try to push you into Chapter 13 rather than let you to file a Chapter 7. So, but with the taxes and the business debt, if it's more than 50%, then you can file Chapter 7. So that's a big thing to keep in mind.
Interesting. So it's not only that there's a Chapter 7, but there's a test to see whether you qualify. And then on that particular test, if it's a business, if it's either business or non-consumer, which are the kind of the non-credit card and stuff, that you may not even have to deal with that income tax. That's very interesting. Yeah. You talk like it's simple, and I know it's complicated. I think let's have people, if you guys have a question for Rich, you have a situation where you may or may not qualify for bankruptcy. It may or may not be an option. Sometimes bankruptcy is an option that is used, that is done in conjunction with other things. Like maybe you need a bankruptcy to get rid of all of your credit card debt, and then you deal with the tax debt separately, like with an offer in compromise or something. That's the kind of stuff that you find Rich doing at GQ Law. If you want a consultation with him to determine whether your situation qualifies for which options it qualifies, it's 855-500-TRUST. And again, that same number is to get a hold of me dealing with your estate plan, your trust administration, how to be a trustee, that stuff, 855-500-TRUST. Listen to the Word on Wealth. Tomorrow it's estate planning day. Tomorrow, Wednesday, real estate Thursday, all things money. And Friday, we got Finding Joy Friday again. Rich, thanks for being on the air with us.
Great to be here as always.
Yeah, really appreciate it. So there you go. Rich, the fresh start, man. Give him a call, 855-500-TRUST. Talk to you tomorrow, everybody. Thank you.
Tell a friend about the Word on Wealth, featured since 1995, with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinions expressed here do not necessarily represent the views of Salem Media Group or its sponsors.
The airing of this program by this station